Good afternoon again, everyone. Charbel Barakat here. A big hearty thanks to Attorney General Ashley Moody for her wonderful for her remarks. She's a great friend of the Federalist Society. Now we'd like to jump into our luncheon panel that we're very excited to share with you, a virtual discussion on corpus linguistics. I'll give a brief intro to the topic and introduce our moderator. But first, just a reminder to those in the room, we certainly are welcoming of your questions. We would ask that you please write your questions down on index cards that are placed at your seats and raise your hands with those completed questions and those cards, and our staff will gather those up and bring them to the moderator. So a bit about our panel and our discussion topic this afternoon. Corpus linguistics has recently emerged as a method for addressing problems in legal textualist interpretation. Corpus linguistics draws on evidence of language use from large coded electronic collections of natural language that can be designed to sample the linguistic conventions of a wide variety of speech communities, industries, or linguistic contexts. And corpora have begun to see increasing use by judges, scholars, and advocates, including in the United States Supreme Court. The panel will first provide an overview for those unfamiliar with corpus linguistics, and then address advantages and limitations of using language evidence from linguistic corpora in legal interpretation, such as when interpreting contracts, statutes, or constitutions, as well as highlight the use of corpus linguistics in recent cases. And I think you'll all agree this is a tremendous panel, capped off by one of my favorite judges, certainly a friend to the Federalist Society, and needs no introduction to this audience, but a highly regarded public servant who served at all levels of government, and who we're proud to have as a judge on the Middle District of Florida. We welcome our friend, Judge Wendy Berger.
Got a little seat change. Thank you, Charbel, for that introduction. I'm thrilled to be moderating this afternoon's discussion on corpus linguistics. We have a distinguished panel. They're all recognized as experts in the field, and they're here to discuss with you their studies on the subject, its relevance in the legal profession, particularly as it pertains to the application of the law and the pros and cons of judges relying on various corpora when tasked with construing legal text, and of course the ordinary public meaning of its terms. With that said, I'd like to introduce our panel. First, we have Justice Thomas Lee from the Utah Supreme Court. Justice Lee was appointed to the Utah Supreme Court by Governor Gary Herbert in July of 2010. Before joining the court, Justice Lee was the Rex and Maureen Rollison Professor of Law at BYU Law School, where he continues to serve on a part-time basis as a distinguished lecturer in law. He graduated with high honors from the University of Chicago Law School in 1991. And after law school, he served as a law clerk for Judge Harvey Wilkinson III of the United States Court of Appeals for the Fourth Circuit, and then for Justice Clarence Thomas of the United States Supreme Court. He then joined the law firm now known as Parr, Brown, Gee & Lovelace, where he became a shareholder before joining the law faculty at BYU. During his years as a full-time law professor, Justice Lee maintained a part-time intellectual property litigation practice with Howard, Phillips, and Anderson. He also developed a part-time appellate practice, arguing numerous cases in federal courts throughout the country and including the United States Supreme Court. In 2004 and 2005, he served as Deputy Assistant Attorney General in the Civil Division of the U.S. Department of Justice, and we welcome Justice Lee. We also have Professor Lawrence Salon of the Brooklyn Law School. Professor Salon is the Don Porcelli Professor of Law and Director of Graduate Education at Brooklyn Law School in New York City. Professor Salon holds both a law degree from Harvard Law School and a PhD in linguistics from the University of Massachusetts. His scholarly works are largely devoted to exploring interdisciplinary issues related to law, language, and psychology, especially in the areas of statutory and contractual interpretation, the attribution of liability and blame, and linguistic evidence. He is director of Brooklyn Law School's Center for the Study of Law, Language, and Cognition, and his acclaimed book, The Language of Judges, is widely recognized as a seminal work on linguistic theory and legal argumentation. Prior to entering academia, Professor Salon was partner in the firms of Orens, Elson, and Lupert, where he specialized in complex civil litigation, before which he was a law clerk to Justice Stuart Pollock of the Supreme Court of New Jersey. Also joining us on the panel is Professor Kevin Tobia of Georgetown Law Center. Professor Tobia is an assistant professor of law at Georgetown Center in Washington, D.C. He received his BA summa cum laude in philosophy, mathematics, and cognitive science from Rutgers University, bachelor's in philosophy with distinction from Oxford as an Erdogan scholar, and his JD and PhD with distinction from Yale, where he was an articles editor of the Yale Law Journal, Coker Teaching Fellow in Torts, and Prize Teaching Fellow in Philosophy. Kevin's scholarship has appeared in the Harvard Law Review, Yale Law Journal, and Journals of Philosophy and Cognitive Science, and has been awarded the Yale Law School's Felix S. Cohen Prize for Legal Philosophy and the AALS section on Jurisprudence Future Promise Award for Scholarship and Legal Philosophy. And so I welcome our panelists today for this discussion on corpus linguistics, and we'll begin with Justice Lee.
There you go. Can you hear me now? All right. It's an honor to be here. Thank you, Wendy, for that kind introduction, and Charbel and the Federal Society for inviting me. It's an honor to be on this panel with Professors Solon and Tobia. I have great respect for both of them and have enjoyed being on panels with them before. And I'm excited to be here to talk to you a little bit about the tools of corpus linguistics and how they might aid in problems of interpretation. This first slide is just a little reminder to me. This is the compare and contrast of how I expected to wake up this morning and how I actually woke up this morning to a snowstorm here in Linden, Utah. So wish I could be there with you all, and nonetheless look forward to trying to interact together in this virtual forum. So I'm going to mostly be talking about statutory interpretation. The principles that I'll be introducing will overlap and can overlap certainly with constitutional and contract interpretation. In any of those settings, the starting premise of any problem of interpretation is to try to find the ordinary communicative content of the language of the law. This is a basic premise that we start with, that we try to understand how words would be used in the mouth of a normal speaker of English. There's a famous quote from Oliver Wendell Holmes along those lines, as well as the way he framed it in the McBoyle case, the rule of conduct laid down in words that evoke a picture in the common mind. So the threshold interpretive task is to try to discern communicative content, meaning, how are words understood? Often, sometimes the language is plain, sometimes it's not. And when it's not plain, we're left with what Justice Frankfurter referred to as a contest between probabilities of meaning. I'll come back to that later. The place to start, I think, is to understand why we credit ordinary communicative content. And I've got here some language from Justice Scalia from A Matter of Interpretation in terms of the way he framed it. This is sort of a classic textualist argument of how the premise that understanding language is a better way, a more constraining way, a more limiting way of discerning the meaning of the language of the law than trying to make a guess about purpose or intent divorced from language. I want to come back to this as well. It's not just textualism, however, that thinks that we ought to take seriously the idea of the communicative content of the language of the law. Justice Kagan a few years ago said, we're all textualists now. Not everybody would agree with that framing, but I think to the extent that's accurate, it's getting at the idea that even those who approach the interpretive task as an intentionalist or a purposivist think that we should start with the language of the law and try to discern its communicative content. And the reasons why go to premises of the rule of law and concerns about notice and predictability and reliance interests and neutrality and consistency. And Bill Eskridge, hardly a textualist, has gone so far as to suggest that the search for ordinary meaning may not always yield predictable answers, but it does yield greater predictability than any other single methodology. I want to talk a little bit this morning in terms of trying to take seriously the communicative content of the language of law. 3 different cases. I'm mostly going to be talking about the first one, a U.S. Supreme Court case called Muscarella versus United States, but I'll mention briefly 2 Utah Supreme Court cases. I have, in my judicial writing and later in some academic writing that I've done, started down the path of suggesting the need to use the tools of corpus linguistics to try to discern the communicative content of the language of law. In each of these, and 2 of them are listed here, Canton and Richards versus Cox. In each of the cases that we're going to discuss briefly, there is a problem or a question of lexical ambiguity, meaning a term in a statute that can be understood in multiple ways. So you look at a statute like the one at issue in Muscarella. This is a mandatory minimum sentencing provision of the federal code that says if you carry a firearm during and in relation to a drug trafficking crime, you're subject to a mandatory minimum sentence. And the question in Muscarella is, what's the ordinary meaning? What's the communicative content of carries a firearm? And specifically, is it limited to carrying it on your person, or does it extend to transporting it in a vehicle? The Canton case raises a question of what is the meaning of out of the state? Is that phrase, does it make reference to physically being outside of a state's geographic boundaries? Or as the Canton argued it in that case, is it more a question of sort of legal presence? If you're outside the jurisdiction of a state, are you out of the state? Richards versus Cox is a constitutional case. It raises also a lexical ambiguity question. What does it mean to have employment in the Utah education system under a state constitutional provision that prohibits the use of a partisan test as a condition of employment in? And in that case, again, the question came down to what's the ordinary meaning of employment in? Is it a legal employment relationship, or is it enough to provide services that are of use to the Utah education system? In each one of these cases, the courts are asking this question of ordinary meaning. And in each of these cases, I think can also be marshaled or presented to highlight shortcomings of standard approaches to our inquiry into ordinary meaning. The shortcomings go to both the way we theorize the ordinary meaning inquiry and the way we try to measure it. Let me speak briefly to the sets of problems that arise with respect to theory and with respect to tools of operationalization or measurement, and then I'm going to illustrate the problem in the context of the Muscarello case in particular. Part of the problem, or part of the difficulty with the ordinary meaning inquiry, is that courts aren't always super consistent in what we mean by ordinary meaning. In my academic writing, I've suggested there isn't necessarily an ordinary meaning of ordinary meaning, that courts are a bit all over the map in terms of, we're really good at saying this is something we aspire to, not so clear about what exactly it is we're aspiring to. I've identified sort of a continuum. Sometimes when we talk about ordinary meaning, we mean, well, that's just a possible way to use the language. Sometimes we seem to suggest, well, that's a very common way to use the language, and other times we seem to be saying that's the most frequent or most common way to speak. Elsewhere, we may sort of be talking about, well, that's the first thing that comes to mind when we talk about particular language. There are also sort of measurement deficiencies. I'll get into some of this in particular. Maybe I'll just jump to the Muscarello case in particular, but here are some tools that are used. Human intuition, certainly. We refer to dictionaries. Sometimes we refer to the etymology of a word. We look to canons. We look to legislative history. Essentially, I think there are problems with each of these tools, deficiencies and shortcomings with each of these tools, and a need for additional tools and additional evidence. So you can look at the Muscarello case in particular and see some of these problems. The majority opinion in the Muscarello case, so Frank Muscarello gets arrested in a drug deal. He has transported a gun in a locked glove compartment of his pickup truck, and the question is, has he carried a firearm in the ordinary sense of that term? The majority opinion says yes, he has. The ordinary meaning of carry includes transport in a vehicle. And Justice Breyer's majority gets there in the following way. He says, look, transport in a vehicle is a very common way of using the term. He does a little bit of sort of corpus-like analysis in a nexus search of newspaper articles. And he says, look, I found a bunch of examples. Many of them are consistent with my understanding, with the majority understanding of transport in a vehicle as carry. He also looks to the Oxford English Dictionary, and he looks to the way that the OED orders the dictionary definitions. And he says, look, the transport in a vehicle sense of carry is listed above the transport or packet or carry it on your person definition of carry. And that, he says, is an indication that it is the ordinary sense, or within the ordinary sense, to transport it in a vehicle. He also looks at the etymology of the word, traces it to Latin and Old French. Justice Ginsburg mounts a defense, and she raises this question about, all right, if it appears a third of the time, it makes you wonder, what appears 2/3 of the time. And she suggests that the more plausible accepted meaning of carry is to transport it on your person. She also relies on the lenity, on the rule of lenity canon. The basic problem, which I don't have a ton of time for here, is that none of what Justice Breyer is doing in the majority really gives a very reliable indicator of the ordinary meaning of carry. The Oxford English Dictionary tells us specifically that the way it orders its senses is historical. So the fact that transport in a vehicle appears first in the OED really doesn't tell us anything about whether that's a more common or more ordinary understanding of the way that term gets used. The etymology point is at least as equally problematic. Our English language certainly evolves and is traced back to other languages, but we don't understand our current language in the 21st century based on the way the words may have come into being, in past centuries from prior languages. If that's the way language worked, then October would be the 8th month of the year, and an anthology would be a bouquet of flowers. So that just doesn't do much for us. And the Corpus Linguistics project, the idea of Corpus Linguistics is that we can get some additional evidence of the way language is ordinarily used by ordinary speakers of English by looking at samples of natural real world language in large bodies of text. By doing so, we can get a sense of not just the verb carry, but carry in connection with a firearm, or not just the state and out of the state, making reference back to that Canton case, but we can get broader sort of phrasal context and get some evidence of how language is actually used. Corpus linguistics is a tool then that will tell us something about ordinary English language usage. It's not a theory of interpretation. It's not the assertion that statutory terms have to be understood to incorporate the most frequent use of a given term in a certain corpus. The question of what to do with language evidence that you can get from a corpus tool is a question for legal theory. I am not suggesting that intuition is an impermissible tool or that dictionaries are impermissible, simply suggesting that this is an additional tool and some additional evidence that you might be able to bring to bear to answer these sorts of problems of interpretation. I don't have time to get into this in any detail. I want to hit this quickly and then hit a couple of points of conclusion to make sure I leave time for the other panelists. But you can do some corpus analysis on each of the cases that I've mentioned, and we have done in the Canton case and in the Richards case. I wrote opinions, our court wrote an opinion in Richards, I wrote an opinion for the court in the Canton case, suggesting that one way to understand or get evidence of the way these terms are used is to look at, in Canton, it was a Google News search. In Richards, it was the corpus called the Corpus of Contemporary American English, which is the COCA. And you can get some real world evidence of how language is actually used. At least arguably that language or that corpus analysis suggests that Justice Ginsburg may have had a better argument, at least to the extent the back and forth between Ginsburg and Breyer has to do with the frequency or commonality of using the verb carry in connection with the firearm. Justice Ginsburg seems to have had the better of the point. Now that's a big if. Again, corpus linguistics doesn't take a position on whether that's the right way to interpret the statute. But you can at least get this out of the corpus. Carry on your person is a more common way of using that verb with respect to carrying a firearm. The physical sense of being out of the state is overwhelmingly, maybe even exclusively, the way that we use that phrase. And with respect to that phrase, employment in, we almost always use that in connection with a formal employment relationship and not just sort of broadly using someone's services. So does the corpus give us evidence of ordinary meaning? The answer is it depends. And Professor Tobia will talk about some of the concerns that he has and criticisms that he may want to raise. I think it depends on a number of things. It depends on our legal theory of ordinary meaning. It may depend on whether we think we have a better, more reliable indicator of ordinary meaning. And it also depends, frankly, on whether the senses that we're trying to measure are truly distinct from each other. The closer two senses are to each other, either linguistically or legally, I think the harder it is to draw much of an inference from the corpus evidence. So in Muscarello, for example, you might think that transport on your person and transport in a vehicle are really not distinct senses, but just two different examples, a more common and a less common example of the same sense. And if that's true, then maybe the corpus evidence don't get you very far. I'll just close with this. I think that the shortcomings and criticisms of this tool are significant, and Kevin has some significant concerns that he will raise. I think the burden for anyone who's approaching a problem of ordinary meaning, nonetheless, it's still to sort of ask yourself, what is the path forward? How do you want to deal with problems of interpretation? The standard picture is a shorthand phrase sometimes used to refer to the idea of trying to discern communicative content. Maybe your reaction to all of this is language is just too hard or it's meaningless and we should abandon our search for communicative content. I don't think we ought to do that. And I think there are too many reasons embedded in our rule of law commitment to the language of law to do that. Another possibility is we keep using tools that are available to us now that I think are faulty and fall short. A third possibility, and this is the one that I favor, is to confront the problems, to try to improve and develop the theory and the methodology. That's what I'm seeking to do. I think that Professor Tobia's contributions can help us, and there's much more work to do in the future, but I think that all of this is important, and I look forward to further discussion from the panel.
Thank you. Justice Lee, we'll hear now from Professor Tobia.
Thanks very much. I'm also going to share my screen. Let's see. Great. So can you see this now? The slideshow? Okay. Thanks very much to the panel organizers for the invitation. You've been working on this for a long time, I think, way back in December. So I really appreciate the invite, and it's nice to be here discussing with Professor Solon and Justice Lee, as we discussed before. So today, what I want to talk about, I'm actually going to start before getting kind of deep into the theory with just a couple figures about something that I find pretty striking about all of this that is notable, which is that over the past 10 years, and in particular the past 3 years, this has kind of moved from an academic debate to something that's having a real impact. So there's a number of legal opinions that are discussing and or using corpus linguistics. So if you note the y-axis, it's numerically it's not that many, but still even in recent years, 8-10 opinions a year discussing or employing corpus linguistics analysis. It's a pretty notable trend. Another notable trend is that by and large, originally for the first 7 years, these cases were mostly coming out of Utah, from multiple judges, but coming out of Utah. And really in the past 3 years, the influence has kind of grown tremendously. So there are, as we heard, citations to corpus linguistics in the Supreme Court, various circuit courts, state courts. And so it's hard to know what the future might bring, but I think one theme of the talk that I'd like to kind of leave you with is that it seems like, to some extent, the corpus linguistics, legal corpus linguistics movement has had some tremendous success. And so I join Justice Lee in really thinking that, kind of where the debate is at now is going to be focusing on identifying clear best practices, right? What are the, insofar as judges are using corpus linguistics, how should they be doing it? Because one way to look at it is judges are using corpus linguistics. One other kind of fact to pull out here is that something that's also kind of striking. By and large, the majority of opinions that are citing corpus linguistics are actually conducting their own analyses. So this is a debate. I'm not going to speak too much about it, but some other scholars have written about whether it would be better for judges to rely, say, on expert linguists doing corpus linguistics or to conduct analyses themselves. And by and large, many judges are conducting analyses themselves. Okay, a couple more facts before I turn to some of the what I'll call best practices suggestions. Who's discussing legal corpus linguistics? I don't mean anything too provocative by this slide, but it is worth noting that by and large, it's been Republican appointed judges that are citing and or conducting corpus linguistic analyses, more so than Democratic appointed judges. That fact in itself is not necessarily troubling. But I think one kind of note is that by and large, the Republican justices citing it have been citing it favorably, while the Democratic appointees have been discussing it more critically. And so I think many of the proponents, kind of critics like me or more enthusiastic proponents of corpus linguistics are really attracted to the neutral, objective promise of the tool. And so I think facts like these give some reason for a little bit of caution. And so one of the key lessons that I want to suggest is that, insofar as corpus linguistics has largely been taken up favorably by Republican appointed judges, one key question that I really want to address here, but that is, I think, a key question, is will those favorable of legal corpus linguistics be similarly moved when it reveals evidence that supports outcomes of varying political balances? So I've cited here just one example by a scholar, Neil Goldfarb, who's done corpus linguistic work on bear arms in the Second Amendment. So he's found using corpus linguistics, that bear arms originally carried an idiomatic sense, a military sense. And so there are lots of other examples like these. And so I think one of the kind of key questions and one of the ways that the corpus linguistics movement can, I think, promote this and kind of make true on these promises of neutrality would be to sort of think about these sorts of issues. And I mean, again, I don't really mean anything critical right now, but I think it's an important question kind of looking forward in terms of the neutrality and objectivity of the method. The part I want to talk about really in this set of comments is that the judicial use of legal corpus linguistics is increasing, which, as I said before, is really striking. And the proponents of the movement, Justice Lee, Stephen Morrison, or Ode, I think, like a sincere congratulations. It's actually, to see something new in interpretation is quite rare. And so that in itself is a remarkable fact. And given where we are, right, that most judges are themselves conducting these corpus linguistic analyses, I think one of the most important questions going forward is, if one's going to use this, how should you do it? So that's the question I really want to turn to for the rest of these comments. In framing that question, I think it might be helpful to distinguish three sets of possible responses to that answer. So one is what I'll call the corpus enthusiast. So this is the answer that, kind of broadly speaking, let's use corpus linguistics often. It's the best evidence of ordinary meaning. It outweighs other inferior sources. The other end of the spectrum is the corpus skeptics, who say essentially, never. This tells us nothing of interest. We shouldn't be using this tool in interpretation. My hunch, I'll let the other panelists speak for themselves. My hunch is that all three of us are actually corpus moderates. So I think actually there's a lot of agreement here, to be honest, that the tool is not useless, unlike what the skeptics might say, but it won't tell us everything. And there are various circumstances in which it's not going to be very helpful. So just to kind of put a few faces and names to these different positions, this is here's my Florida reference. So this is Professor Stanley Fish, who's just down the road in Miami. And so Professor Stanley Fish has written a somewhat critical blog post a couple of years ago where he argued that in legal corpus linguistics, when you detach the patterns from the intentional context in which they had significance, you can not get that significance back. So his argument is essentially, when you do these searches, you search for carries in the corpus and you find a bunch of different examples in newspapers. The generalization that you might draw about how carries are used across all those different contexts is ultimately not going to be very helpful in understanding what it means in the particular legal context. Once you kind of strip the data from that context, you really can't get back the significance it originally had there. Another kind of skeptical view is from Donald Drakeman. This is a recent paper where he argues that searching Kothia, which is a corpus, those searches are unlikely to be more accurate than flipping a coin, right? So in his view, it's basically no better than chance doing a corpus linguistics search. And so this is also, I would describe a sort of skeptical view. The view is by and large, corpus linguistics really shouldn't be used at all. It's not helpful, doesn't tell us anything. No better than flipping a coin. On the kind of other extreme end are the corpus enthusiasts. So I'm not really sure how many corpus proponents would subscribe to this view. It's, but kind of for the sake of completeness, one subscribed to this view might say something like, corpus linguistics is the best interpretive tool we have. We should replace the use of dictionaries, intuition with corpus linguistics. So that would be the kind of more extreme corpus enthusiast view. As I mentioned before, I think where the debate is now, I understand most of the people who are speaking and debating corpus linguistics to kind of be converging on this actually quite broad spectrum of moderate views. And so one way to put that set of views, hopefully, which is not too controversial, but it's up for debate, would be to say, well done legal corpus linguistic analyses, good legal corpus linguistics might in some circumstances provide relevant evidence about ordinary meaning. Some implications of this view, sometimes it won't provide evidence about ordinary meaning. Sometimes it's just not going to be helpful. It's also not perfect. It might provide evidence of ordinary meaning, but it's not the source of ordinary meaning. It's not like the Rosetta Stone that we look to determine ordinary meaning. Other interpretive sources could also provide evidence. Actually, Justice Lee and some other in a recent paper have written about triangulation, the idea of using corpus linguistics with other tools in a kind of collaborative way to try to find ordinary meaning. And I think to me, that's a kind of hallmark of this more moderate corpus linguistics view. So what I want to do with the time I have left will be to kind of drill down on this word well done. What is well done corpus linguistics? What does it mean to do good corpus linguistics? This is a big question. I'm going to offer a few thoughts, but I think this is really kind of the key question going forward. And that's one theme I want to leave everyone with. There's a lot of text here. Here are 8 different points that I'm suggesting. There's no way I can talk about every one of them, but if people have questions about any of them, I'd be happy to talk about that in the Q&A. I'm going to really just highlight 3 of them here. So first, I'm going to talk about representativeness. So all participants in the legal corpus linguistics debate agree that corpora should be representative and balanced. This is a principle in corpus linguistics more broadly, which is a field of linguistics that studies lots of different questions, right? Not just legal interpretive ones. What this means is that, well, in the words of Douglas Biber, representativeness in a corpus is the extent to which a sample includes the full range of variability in a population. So what does that mean in the context of trying to find the ordinary meaning of legal text? It's actually a kind of hard theoretical question, right? There's a lot to be said about that. But one thought might be, in particular, if we're focused on these reliance interests and notice values, that we're trying to understand using corpus linguistics how ordinary people understood or would understand the legal text. Right? It's not a question about the elites that produce the text. It's supposed to be a question about how people understand it or would understand it, all people. And so, one kind of question going forward will be to think, are the corpora sufficiently representative with respect to this ordinary meaning task? So as just one example, the Coffea, which is the corpus that's commonly used in constitutional interpretation for founding American English, 97% of the documents in that corpus come from the founders online. That's the correspondences and papers of 6 elite men: Washington, Adams, Hamilton, Franklin, Jefferson, Madison. So it's not a decisive concern, but it does raise the question, right? If the kind of shift, right, from intent to meaning is largely tracked by corpus linguistics, right? We're really focusing on how people understood the text, not on how particular elites produced it. Is that corpus going to be representative in the sense that we want it to be to answer that theoretical question that, say, originalists and textualists are trying to answer? Okay, here's another of the kind of recommendations I want to briefly mention, which is, and Professor Solon possibly will also talk about this. So this is, I've sometimes referred to this as the non-appearance fallacy. Professor Solon has written about the blue pitta problem. And so this idea is that the non-appearance of some use in the corpus doesn't necessarily mean that that use is outside the ordinary meaning of the term. Okay, what does that mean? So let's imagine that we're trying to understand the original meaning of bird. We want to know whether the blue pitta, is a bird. So in a corpus linguistic search, it might turn out that we actually find no references to blue pitta in the context of bird or around bird. There are no references. The intuitive idea, and I've done some experimental work that also supports this, is that there are lots of examples where we're inclined to say, if you ask people right now, is the blue pitta a bird? Most people would say yes. But we might not be able to find blue pitta referred to as a bird in the corpus. And so I think it's a little bit of an obvious point, but it's a pretty fundamental one, right? That the corpus linguistics data, although it's very rich, although there's lots and lots of sources, not everything might be there, right? So ordinary meaning is not every aspect of ordinary meaning will have a reference in the corpus. Some corpus linguistics proponents have argued that this fallacy, the non-appearance fallacy, is a straw man, which I think is a sort of reasonable response. So the idea would be that although critics like me have argued that this is a deep problem, no one actually makes this argument. And to the extent that that's sort of the statement from legal corpus linguistics, I think that's great. I think that's an area of convergence if we all agree that this is a sort of bad style of argument. I want to just raise, as an example, the citation of corpus linguistics in the Supreme Court. So this is a commonly celebrated example of corpus linguistics. So this is Justice Thomas citing legal corpus linguistics as evidence. It's a pretty short reference, but what Justice Thomas writes in Carpenter is that at the founding, search did not mean a violation of someone's reasonable expectation of privacy. The phrase expectation of privacy does not appear in collections of early American English. There's some room for debate, but I would read this as something like a non-appearance argument. So kind of functionally what happened is that we've entered the phrase expectation of privacy into the corpus. We found no results. And then there's an inference drawn from that non-appearance about the meaning of some term. And so I think in the same way, right, if we enter blue pitta in the corpus and we find nothing, that doesn't mean blue pittas don't exist. It doesn't mean blue pittas aren't birds. And so if these arguments really are ones that we shouldn't be making, one other recommendation I make would be sort of kind of going forward, looking at how corpus linguistics is being practiced in the courts, as the graphs indicate it is, and really making sure that the arguments reflect the arguments that theoretically we think corpus linguistics supports. This is the last point. So I want to just speak briefly on intuition. So this is, I think, another area of convergence between corpus proponents and critics, at least critics like myself. So one of the motivations for corpus linguistics is that intuition might be biased. So kind of what's the alternative to using corpus linguistics? Well, maybe a legal interpreter will look at a text and just sort of use their own intuition to make a judgment about what the ordinary meaning is or was. And corpus linguistics scholars, legal corpus linguistics scholars have, I think, rightly raised some questions about this. Might that lead to motivated reasoning? Does that allow, certain types of bias to enter into interpretation? Instead, we can use corpus linguistics, which promises a certain kind of objectivity. One challenge with this is that at least in the modern version of legal corpus linguistics, the version that every judge in the graph I showed has used, the analysis of the concordance lines is fundamentally based on intuition. So when we search in the corpus, we see, how is carry used? We want to determine Mascarello. We look at all these different examples of how carry is used in lots of different contexts. How do we determine from that which one of the two senses is present there? Well, essentially we make an intuitive judgment. And so I think here too, a little more needs to be said about kind of what exactly distinguish, if there are these problems with intuition that motivate corpus linguistics, what are the ways that corpus linguistics can avoid some of those same pitfalls? Now, in fairness, there are some ways. So Justice Lee actually in an article has done a really nice analysis where he employed coders, two different coders, to make judgments about concordance lines. So, right, two different people judge the lines, and then you can look as a researcher and see, did they agree in their categorizations? Carry over here means this, carry over here means that sense. That kind of approach, I think, actually goes a pretty long way to speaking to some of these concerns about intuition. But here again, there's a little bit of a gap between what's gone on kind of theoretically and what's happening in the court. So to my knowledge, none of the uses by judges in courts have used coders or blind coders. That would be coders that aren't aware of the particular research question. So in conclusion, I just want to say legal corpus linguistics is off the ground. And as I said at the outset, I mean this sincerely, it's really a remarkable accomplishment. In the words of Larry Solom, not Solan, Solom, it might revolutionize interpretation. And then, the main theme I want to kind of bring across is that while the old debate was framed as one between skeptics and enthusiasts, the question being, should judges ever look to legal corpus linguistics data? I think the new debate really should be one within this camp of corpus moderates. What makes for good corpus linguistics, right? I think that's the key. And to be fair, Justice Lee's presentation, I think, was really focused on that question as well. And my sense is the three of us share this kind of sense of urgency in answering this question. And so the questions to ask going forward, I would propose would be, what are in fact the minimum standards of legal corpus linguistics? So I've proposed 8 here. And when we look to the courts, are the legal uses of legal corpus linguistics actually meeting those best practices or not? So I've given kind of a lot to think about. I just want to say thanks very much for your attention, and I look forward to your questions.
Thank you. We'll hear now from Professor Salon.
Hi, thank you very much. First, let me begin the way my co-panelists began, by thanking the Federalist Society for inviting me. I'm delighted to be here. And by here, I don't mean in the chair in my den, which is where I am physically, just to take off on the Utah case that Justice Lee talked about, but of course among you. And I do know both of my co-panelists well, and I'm really delighted and honored to be part of the panel of the three of us. Now, I have to say that I really am a legal corpus linguistics moderate, as Kevin described, and apart from, you need to distinguish between LCL, which is legal corpus linguistics, and LDL, which is low density lipoprotein. So I'm an LCL moderate, and I hope I don't have too much LDL. Now, I'd like to talk about a few cases that illustrate both some of the advantages and some of the pitfalls of using corpus linguistics in particular cases, and then see if we could draw some more general conclusions from these examples. And the first one is a case that Justice Lee has written about, but did not talk about today, and that's a case called Taniguchi versus Saipan Resorts. Taniguchi is a Japanese baseball player, and he went to a resort that's in an American territory, and he was and he was injured when a deck kind of collapsed from under him, and so he sued them in federal court. And after discovery, the court awarded summary judgment to the defendant, to his opponent. And then the opponent made a claim for costs. And under the federal statute, costs include compensation of interpreters, among other things. Obviously, they don't include attorney's fees unless there's a specific fee shifting law. So the question was, does the compensation for the cost of interpreters include the cost to translate many documents from Japanese into English, because the case was tried in federal court here, and the opinion of the majority in that case, it made its way up to the Supreme Court eventually, and Justice Alito wrote the majority opinion, and he said, and Justice Alito said that no, it does not include, that interpreters and translators are two different sets of professionals, and he used various resources. And Justice Lee, along with his sometimes co-author and his former law clerk, Stephen Morrison, look at the case, and they do a corpus analysis of the term interpreter, and find that translation and interpreting is generally considered separate activities. That is, when you read what they say about when you read the contexts in which interpreters is used to describe particular translation activity, they're talking about verbal speech. And when you read what translators do, they translate written language, typically, not always, but typically enough. So he said, yes, Justice, they said, the scholars said, yes, Justice Alito really had it right when he was saying the ordinary meaning of interpreter is for the translation of oral speech and not of written documents. And that's how the term is generally used. I think that's a very good use of corpus linguistics. I think it bolsters Justice Alito's analysis, but it might not have. That is, it's a perfectly reasonable way of making an investigation as to whether the majority got it right in that particular case. Now, that doesn't mean that you need to look at the ordinary meaning. Justice Lee was absolutely right in his talk. Whatever theory of interpretation you have, the corpus analysis will be helpful for some, but not all of them. But that's the example. I think it's a very good use, and I think the scholarly literature is right on point. Now, compare that to a place where I think I disagree with Justice Lee, and that is the Muscarello case. That's the case involving carrying a firearm during and in relation to a drug trafficking crime, where that's exactly what Muscarello had in his car. Majority, it was 5-4 decision, hotly fought with colorful examples on both sides. And Justice Breyer for the majority said that that yes, he was carrying a firearm, and that having it on your person just is less like packing heat, is a very specialized meaning, far from the ordinary meaning, and so on. And he had certain dictionaries and so on. In this dissenting opinion by Justice Ginsburg had her own dictionaries, and they battled it out in ways that I don't think was reflected the dignity of that court all that well. With looking at literature, Robinson Crusoe carried this or that. Oliver Goldsmith used carry in the opposite way, and so on. They both had references to the Bible, as if it's good enough for the Bible, it's got to be good enough for the court, but the Bible references went in both directions as well. Now, I think that this case is more like the situation that Justice Lee talked about at the end of his presentation, which is what happens when you have a term that, rather than being ambiguous in that there's two quite different senses, it just doesn't say enough. It's indeterminate. So maybe carrying has really only one general sense, but there's more than one way of carrying things. So, for example, if I'm left-handed, and if I carry a briefcase, if my briefcase is heavy enough, I'm likely to carry it in my left hand. If it's not, it doesn't matter so much. But if I carry it in my left hand, you wouldn't say, well, that's one kind of carrying, and another sense of carrying is carrying it in your right hand, and so on. You could say that carrying it in a vehicle or carrying something on your person are really just two different ways of carrying something, and we don't really distinguish in our own mental lexicons between the two. That's at least where my thinking is right now. I'm not positive about it though, but I think that I'm not sure that corpus linguistics is really telling us too much. Now, there's a third case that I want to talk about, an old case, and that is the case of Church of the Holy Trinity versus the United States. This case has been written about by many, many people. Justice Scalia hated it. It was kind of a punching bag for him because it looks like anyway that it used legislative history to trump ordinary meaning, and that to him is not, it was an improper kind of analysis. But as far as that case is concerned, what happened was, many of you know it, but some of you don't. A wealthy Episcopal church in Manhattan paid to bring its new rector from London to Manhattan to serve in the church. And there was a statute that made it a crime to pay the transportation for a person who's under contract to perform labor or service of any kind into the United States. The reason for that statute was that there had been in the late 19th century, a big movement to bring over large groups of immigrants in boats, largely from Hungary and Italy. They were paid very poorly. They were driving wages down in various places, affecting the American labor market. Obviously, if there was no need for them, they wouldn't have had jobs either, but there was enough work to go around as long as you started by hiring the cheaper labor, and that's really what was happening. And the Supreme Court of the United States, 9-0, said this statute doesn't apply to a wealthy religious institution bringing in a new rector. This is really about hiring physical laborers, and we're not going to apply it to that particular situation. It was an intentionalist argument. Now, I did a corpus analysis, and along with a linguist that I write with sometimes named Tammy Gales. And what we found was that, first of all, the expression labor or service that you see in that statute is actually a term of art, a legal term of art. So the Article 4 of the Constitution refers to service or labor, meaning slavery. It's the fugitive slave provision that says that if you have a fugitive slave going into a free state, you have to return him or her to her owner. And there were 2 fugitive slave acts that were enacted that use exactly the same language. So this is the first lesson about corpus linguistics, which is that corpus linguistics, if you're going to use it, you have to use the right corpus. That's one of Kevin's 8 principles, and it's not always easy to know. So if you're looking at how the words, if you look at labor or service as a disjunction, if it's labor or if it's service, then you violated the statute. Well, then they probably had violated the statute, because this really was you can say that it's unusual to say that a minister is performing labor. You can do it, but it sounds very strange. But it's pretty hard to say that he wasn't performing any kind of service. And the majority, the unanimous court in that case actually conceded the point, but then ruled the other way anyway. So so there are lots of cases where words over time acquire legal meanings, and caring only about the ordinary sense of the word may not be the right thing to do. So now I decided not to have any slides, but if I did have a slide, it would have been a picture of a blue pitta. Thank you, Kevin. So, so one problem that we have with corpus linguistics is that that sometimes we need to contextualize the use of the word more than those who practice legal corpus linguistics do. And now the legal principles actually do contextualize them. So there are certain canons of construction, like a eusdem generis and noscitor a socis. If I pronounced that wrong, forgive me. But these are both saying that when a word appears in a statute in a certain linguistic context, you interpret the word consistent with the context. Now, what we see sometimes in the legal corpus linguistics world is context is indeed important, but what they look at is the central tendency of usage. So take the example carry, or the predecessor case of Muscarello was a case called Smith, where somebody tried to trade their unloaded machine gun for some cocaine. And the statute not only prohibits carrying a firearm, it prohibits using a firearm. So did you use a firearm to get your cocaine when you traded it when you got some cocaine in exchange for your machine gun? And a majority, it was a 6-3 decision, a majority said, yes, you did. And Justice Scalia wrote a very colorful and interesting dissent saying, that's not what you usually mean when you're talking about using a gun. You mean using it as a weapon most of the time. And you do mean that, but then the question is, does that mean that the word use is somehow being misunderstood? Or is it simply the case that in the world, we use a gun one way more than we use it another, but there's nothing wrong with calling each of them use? That is this about things that happen in the world, or is it something about language? And there's a pretty good argument that, and this is getting back to Justice Lee's point of earlier today, when there's a pretty good argument that when the issue is which thing happens in the world more often, but it's not about language, the language is perfectly usable in both ways, then we're really it's not a good time for corpus linguistics application. So I think I'm going to run out of time in a minute, and I want to leave enough time for questions. But in conclusion, I want to say that I think that legal corpus linguistics has some very good applications, and it strengthens legal arguments. The Taniguchi case illustrates that. I think that if you use both corpora that have legal terms and corpora that have ordinary terms, and you know how to use them at the right time, you can strengthen the use of legal corpus linguistics, as I think my analysis of Holy Trinity Church does. And finally, as in Muscarello, there are some hard cases where it's not really clear whether that's the right method to use at all. So giving you one case where I think it's problematic one case where I think it's great, and one case where I think it's you need to use two different corpora. I've now successfully defined myself as a corpus linguistics moderate. Thank you.
Thank you, Professor. I think we're going to have a few minutes to let Justice Lee give some final thoughts and response to some of what's been discussed here today. And I just want to remind everybody in the audience that if you have a question, write it down and on the note card and raise your hand, and they will bring the questions to me. So I know it's a very interesting topic and some of you may have questions. So with that, Justice Lee.
Judge Berger, could you let me know or let us know when you'd like me to break for questions? Because I want to make sure and leave plenty of time.
Sure, we have a few minutes. We've been going quite a while on this, and I think that we're supposed to wrap up around 2:15. So we have about 7 or 8 minutes left of our discussion.
Okay. So, but are you wanting me to? Because if you want to use those 7 or 8 minutes for questions, we can. How much of that is that?
I would just give like 2 minutes if you want to respond.
Okay. Very good, thank you. I really appreciate what Professors Tobia and Solon have had to say, and I would just let me just hit 1 or 2 really quick points, and maybe just start by saying I think that Kevin's framework is useful, and the way he's presented it today, I don't know that there's a ton of disagreement amongst the members of the panel. I may have a couple of sort of quibbles, but I think of myself as a corpus moderate in the way that Kevin has presented it. In my judicial opinions, I think I've used corpus tools a handful of times. I've been doing this job for 10 years, so not at all suggesting that this is the answer to all interpretive problems by any means. But let me speak maybe to a couple of quick points. One, the notion or the fact, I guess, that Kevin referred to, that it has tended to be more Republican appointees who have used corpus tools, and I guess you could say textualists as well. You know, one thought that I have on that is that I'm a little bit surprised that it's been limited to that. Larry's point about Church of the Holy Trinity sort of shows that one of the things you can get out of corpus tools is to sort of dig into the assertion that is sometimes made by textualists that the language is plain or it's clear, to the extent old school textualism is take my word for it. I know what this language means and it's really clear, or I found a dictionary definition that I liked and it's really clear. Corpus tools give us a better, more transparent and falsifiable basis for assessing those sorts of problems. So there's no reason that it ought to be limited to, a steely-eyed textualist, much less a Republican. The language of law has no ideology. And to the extent we're trying to understand communicative content of the language of law, it shouldn't matter how you approach your ideology shouldn't make any difference. One or two other really quick ones. Maybe I'll just hit one other one and leave the rest of our time. The reference to the idea that this has been done sua sponte by judges, that's a criticism that was leveled at me the first couple of times that I did this. And I'll just, in judicial opinions, and I'll just say 2 things in response to that. Number one, I absolutely agree that this kind of analysis is better done with input from the adversary process and with input from adversaries who may have employed experts who know how to do this well. And I believe, strongly in the adversary process. Second, having said that, it's my job to get the law right. It's my job to understand the meaning of the language of law. And if the parties don't give me the information or the tools that I need, I think it's my job to do my best to try to interpret and understand the language of law. Justice Scalia once said in response to critics of originalism, to the extent the criticism of originalism is that judges aren't historians or aren't trained in history, his response was, our charge is to try. And I think that's the way it works with respect to language as well. We don't have really a developed field of law linguistics. I think we need one. I think to the extent judges and lawyers are disambiguating language for a living, to the extent 5 years of Frank Muscarello's life depends on whether Justice Breyer gets what he thinks he can get out of etymology or the OED, I think that's a problem. And so I think we need better, more tools and more transparent tools. And I'll just leave it at that.
Thank you. We're getting some questions in, and many of the people that are in the audience today here in Orlando are state court judges, and they're interested in another useful tool for statutory interpretation besides the ordinary dictionary. And of course, I think that they worry or don't have time or the resources available to engage in the level of research that Corpus Linguistics requires. How would you advise them? And you mentioned these other tools. What are these other tools? Where do they go in search of a Corpus Linguistics analysis?
Yeah, I mean, I'll try to take a crack at that. Some of the things that Kevin mentioned, Professor Tobia mentioned, there have been opinions from various federal courts of appeals that have employed tools of corpus linguistics, the Sixth Circuit and the Third Circuit, for example. The Sixth Circuit, if I'm remembering this right, ordered supplemental briefing on a question of interpretation and asked specifically for supplemental briefs on corpus linguistic analysis of a question that was presented in the Sixth Circuit. That's a possibility. I've heard, raised the idea or the possibility of appointing an amicus or, asking for expert input. Those are possibilities. I think in the long run, the hope is that if you build it, they will come, and that eventually there's a sort of field of dreams effect here, that as more and more judges take seriously these tools, more and more lawyers are going to see that they need to present this. And I think we'll see more seminars, we'll see more CLEs, we'll see more judges or more lawyers become familiar with this, and judges will be able to rely on the adversary process.
Are there points of best practices that legal practitioners are using to sort of bring this up to judges?
Yeah, there's a piece in the Brigham Young University Law Review that was authored, I think, by Jesse Egbert and James Phillips that identifies some best practices. Professor Tobia mentioned several of them, and I agree, by the way, with everything he said about best practices. And I think it's super important to get the right corpus. It's super important not to over rely on corpus evidence or assume that it's going to, answer every problem of interpretation. But I think that's a good place to look is at that piece by Jesse Egbert and James Phillips.
May I add something? That there are some corpus linguists who do, including Jesse Egbert, incidentally, who do quite sophisticated statistical analysis of language as part of the method. And at least one of them has written fairly recently that this is the problem with legal corpus linguistics, and that the people who do it, which include me incidentally, don't really have the sophisticated computational tools that the field of corpus linguistics uses to draw the best inferences it can. And I was always a defender of judges just using it sua sponte, because when you see how it's used, it's really something accessible. And lawyers are so accustomed to doing Lexis and Westlaw searches. It's not that much of a jump to say, let's just look through a big database of language. But there are times where the sophisticated corpus linguistics community can do things that the people in the field just don't do. And I don't either. I'm not separating myself from it.
We have one question that says, is there any intersection between the words used in the contemporary legislative debate and the corpus method?
I can say something briefly about that.
Okay.
I think the answer is yes, and I think the answer builds on something I would say in response to part of what Professor Tobia was talking about. Professor Tobia raised concerns about the COFIA database, which is the Corpus of Founding Era American English, a corpus that I propose to use to analyze problems of constitutional interpretation. And I think he rightly raises the concern or the question about whether that's a representative corpus, whether that gives us representative public meaning of the language of the Constitution. Part of the answer to that criticism is that there are sub pieces of COFIA that will let you look at things like newspapers in the founding era. That's not perfect, but it gets you probably as close as you can get to public meaning. The other point I want to make, which is directly responsive, Judge Berger, to this question, is that corpus analysis isn't just about broad general public meaning. You can develop a corpus of any language community that you're interested in studying. And some theories of interpretation would say we may be interested in the meaning of the lawmaker, of those who ratified a constitution or those who voted on a particular piece of legislation. There's some work being done. We're doing our 6th annual conference on law and corpus linguistics next week at Brigham Young University. And one of the papers that's being presented is a paper on how you might go about developing a legislative history corpus. All the materials, for example, that may have been considered before the Congress that enacted the statute at issue in the Muscarello case. And if you were trying to understand, Judge Easterbrook once referred to legislative history in terms of its favorable usage, permissible usage, referred to it as a specialized dictionary. But you might be able to compile a corpus of legislative history and make it sort of coded and searchable and use it as a database in that way.
Thank you. And I want to thank our panelists for joining us today here. Wish y'all could be here in Florida, and we hope to have you back again. But we'll sign off and thank you very much for your participation and for this incredibly interesting topic.